Hello and welcome to the Post-Grant Patent webinar. My name is Landell King and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen, and our technical assistance team will be able to help in any way possible. If you're having issues hearing over the phone, you may press *0 and an operator will be able to assist you. Please note that as an attendant, you are part of a larger attendance. However, the main privacy of the numbers and names of our attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located in the lower right-hand side of your screen. Type your question in the text field and hit send. Please send to default as all panelists. This seminar is accredited for 1.0 hours of Illinois' MCL credit. Please inquire if you wish to seek CLE credit in additional states. During the webinar, you will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar and will ask for the codes. If you have questions regarding CLE, please contact CLE at brinksgleason.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce our first presenter for today, Mark Richards. Mark, you have the floor.
Thank you. Welcome, everybody. Thank you for joining our webinar today. We will be discussing recent developments and decisions at the Patent Trials and Appeals Board at the U.S. Patent and Trademark Office. I am Mark Richards. I'm a shareholder at Brinks, Gilson & Leone. I've been a patent attorney for more than 20 years, handling all areas of intellectual property law. Currently, I am the co-chair of the Post-Grant Patent Practice Group at Brinks. Also joining me today are my colleagues who are members of the Post-Grant Practice Group. Mi-Young Shin, who will be discussing motions to exclude at the PTAB, and also Daniel Parrish, who will be discussing authentication of prior art. So I hope our presentations today will give you some greater insight into how IPR and CBM trials function, which will allow you to provide better legal advice to your business clients. I would like to begin by first talking about the latest statistics to see how far the PTAB has come and where it is going. Then I would like to discuss some recent decisions from the PTAB. The first one involves the burden of proof and burden of production of evidence between a petitioner and patent owner in the context of prior art. And then I would like to discuss a recent decision involving the application of estoppel by the board. So looking at some recent statistics of the total number of petitions for IPR, CBMs, and post-grant reviews that have been filed on a month-to-month basis, we can see there's, in the past year, there's somewhat of a leveling off of the total number of petitions that have been being filed. And so out of the total petitions, there's a significantly many more IPRs being filed. I would estimate about 140 per month on average, whereas there's only probably on average about 12 petitions for CBMs being filed. And with regard to post-grant reviews, since those are relatively recent phenomena, because they're limited to only patents that have an effective filing date since the introduction of the AIA back in 2012, those are just starting to take off, but still we're only seeing on average about 1 per month of those being filed. But as you can see from the zigzagging profile of the month-to-month filing, it's really hard to make any predictions on where trends are going. You know, in the last 2 months, there's been a downturn in filings, but at this point it's difficult to say if that's any precursor of a long-term trend. But what is interesting that this chart does show, from roughly about 18 months ago, there was quite a significant increase in the filings of petitions. And that upward curve in the wave has been referred to as a tsunami wave of AIA trials that are soon reaching termination and will be ripe for appeal at the Federal Circuit. So we're just starting to see a wave of appeals coming out of the PTAB that are being heard before the Federal Circuit. And that trend will definitely continue. So looking at some, what the breakdown is of the different technologies that petitioners are requesting trials on, different types of patents. By far and away, the biggest area are patents that relate to computer and electrical technologies. And that is a trend that has continued last year and is also continuing in the fiscal year 2016, which began with the month of October of 2015. However, one trend that's been very interesting is the recent uptick in the number of petitions that have been filed in the biopharmaceutical space. And the last fiscal year, there was only 9% of the total petitions were for the biopharma patents. But in just the month of October alone, that number has increased to 17%, a significant increase. And I think in part of that is some filings by some hedge funds that are trying to take advantage of the AIA trials to affect the, some people have alleged, affect the stock price of the patent owners. But also we're seeing also a lot of filings by some generic pharmaceutical manufacturers challenging the big pharma patents. So this next slide I'm showing is a recent dispositions of IPRs that have been completed by the PTAB to date. This is an interesting chart that has been provided by the Patent Office that shows the breakdown of all the completed terminated IPR trials. In the top, they see out of a total of 2,200 petitions that were filed, only about half of them resulted in trials actually being instituted. And of those that break down, it's interesting that over 400 of those, or over 40%, have been terminated, either being settled or dismissed during the proceedings. And so we're left with about 630 that actually completed to trial. And of those, I would lump at the bottom, the red and yellow hexagons together, because those are the patents where there were at least one or more claims were found to be unpatentable. So with the result that only about 14% of trials fall into that little green box where the claims were held to be not unpatentable. So that's about 14%. And at the bottom, in comparison for the covered business method reviews, only 3 of about 80 patents have been left unscathed, with all claims found not unpatentable. So that's only 4%. So by far away, if the patent is proceeding in a covered business method review, the odds are not as favorable as if they were in a inter partes review. So in the next slide, which was also put together by the Patent Office, you can shows with an interesting bar chart how few claims are actually found to be unpatentable by the PTAB in a final written decision. And as this slide was presented at a presentation I attended by the Patent Office, I think they were trying to use this to show how the statistics are really not that unfavorable for patent owners going into a post-grant proceeding. You know, I think the PTAB has been nicknamed as the patent death squad, and the purpose of this slide was to dispel that myth. However, if you look at it in a little bit more detail, you can see that the board, when they do reach their final written decision, very few claims actually remain to be found patentable. And on the far right corner, the bar with that little green layer at top, that thin green layer shows that very few, less than 10% of all the claims that have been instituted against in a PTAB trial were ultimately found to be patentable. By far and away, half the claims either were found to be unpatentable by the board, or the patent owners dropped or canceled the claims, or for some other reasons the claims were not subject to a final written decision because the parties settled. So, here it shows that less than 10% of the claims that end up going into an IPR trial end up being found patentable by the board. So let's turn to a recent decision by that came out of the PTAB recently, and I'd like to discuss a case that involves some little plastic cups that have 3D images on them. So the next time you're out with your kids at the ballpark and get a souvenir cup with 3D images on them, you'll be able to explain to them a little bit about how the patent system works. But notice it's an interesting decision because it goes to the difference between the burden of proof and the burden of production of evidence that the different parties have at during a course of an IPR trial. So in this particular case, the petitioner, Dynamic Drinkware, filed for an IPR alleging that National Graphics patent, the 196 patent, was anticipated under 35 U.S.C. 102E by a later published patent. We'll call the 555 patent. And if you look at the timeline at the bottom, the 555 patent has a filing date of May 5th, 2000, which was earlier than the filing date of the provisional that the patent owner's 196 patent relied upon. However, during the course of the IPR trial, the patent owner alleged an earlier reduction to practice date of their invention of March 28th, which predated the filing date of the 555 patent, but it didn't predate the filing date of the provisional application that the 555 patent relied upon. So this wouldn't seem to be that big of a deal. However, the board held that Dynamic Drinkware failed to prove that the 555 patent was actually entitled to the provisional filing date. I think Dynamic Drinkware had argued that it had the presumption of priority to the provisional application and wasn't required to prove that it was entitled to priority, but instead was arguing that the patent owner had the burden to prove that the 555 patent was not entitled to the priority. However, the board didn't agree with that and pointed out how dynamic drinkware, the petitioner had only compared Claim 1 of the 196 patent, the patent being challenged, to show that Claim 1 was disclosed in the 555 provisional application. The board held that was not enough. And dynamic drinkware had appealed that decision and argued to the Federal Circuit that it was enough, and that they had shown that the 196 patent claims were disclosed both in the 555 patent application and in the provisional application to which the 555 patent claimed priority. In a long decision, the Federal Circuit held that this highlights the difference between the burden of production between the parties that shifts during the course of AIA trial or even a trial in court versus the burden of persuasion here. So looking at it in more detail, the initial burden upon the petitioner was satisfied by showing that its prior art predated the filing date of the 196 patent. However, after shifting the burden to the patent owner and they proved an earlier reduction to practice, the petitioner then had the burden shift back to them to show that it was entitled to an earlier filing date, and they could not rely upon a mere presumption of that effective filing date. They actually had to provide evidence to prove it. And merely disclosing, showing that the disclosure of the claims was found in both the patent application leading directly to the patent and into the earlier filed provisional was not enough. And in fact, the Federal Circuit said even showing that the disclosure is the same for both the patent application and the earlier priority provisional application was not enough. You also had to show that the claims in the issued patent were actually supported in the provisional application. So some of the takeaways from here is clearly that going into an AIA trial, you have to be well versed and understand the difference between the burden of persuading and the shifting burdens during the course of the AIA trial. And you have to be prepared to have evidence as the burden shifts. And even better, if you're relying on an earlier filing date of an earlier application, whether it's via a continuation or a provisional, that you identify claims that are supported in the earlier filed application. And you can include that in your initial petition when you're requesting an IPR or CBM or other AIA trial. And one thing that's interesting to note here under the new rules post-AIA, since the 102E prior art no longer exists, here dynamic drinkware would have won under the new AIA laws. So the next subject I want to talk about relates to the application of estoppel and related PTAB proceedings. The statutes give the Patent Office the right to apply estoppel against related proceedings that are before it. And in 35 U.S.C. 32E1, it shows that if that a petitioner cannot request or maintain a proceeding if there was a final written decision that had previously been applied against a claim in a patent, and the petitioner could have brought that same issue in the earlier proceeding. So here in this decision involving Apple versus Smart Flash, there was an earlier filed covered business method review that Apple had filed against the same patent on the same claims just but only asserted prior art grounds for invalidity. Although the PTAB had granted institution of new covered business method review for the patent, they asked for the parties to brief whether or not the new grounds that Apple was asserting of unpatentability under 35 U.S.C. 101 could be maintained, or whether or not the statutes would give some effect of estoppel against Apple in asserting the new grounds under 101. You know, what's interesting is that Apple was arguing that they couldn't have brought that 101 grounds for invalidity in the earlier covered business method because there was a significant change in the law in view of the recent decision by the Supreme Court in Alice Corp. Versus CLS Bank. You know, there's some merit to that argument since right after the Alice decision was handed out by the Supreme Court, the Patent Office clawed back some patents that already had notices of allowances and issue fees paid and clawed them back and withdrew them from allowance to raise new 101 rejections. So although there was some argument as that would seem to hold water, the board decided that the Alice decision was just a clarification of the law and that they could have brought the 101 grounds for invalidity in the earlier CBM, especially since there was sufficient case law that Apple relied upon in its briefing and in its petitions that were predating Alice. So Apple tried to argue that, well, under the technicalities of the statute, it wasn't maintaining this proceeding because the board had already closed the evidentiary record and the only thing remained was the oral hearing. But the board said that even participating in an oral argument was maintaining a proceeding, and in which case the estoppel could be effective to prevent the case from ongoing. However, the board didn't terminate the case. Instead, it dismissed Apple from the proceedings and decided that the board of it, since it's had its own authority to maintain a proceeding, it could continue to reach a final decision. So I think one big takeaway here we can learn from this decision is that when you're filing a petition, you know, it's best to consider all possible arguments that you could present, and if you have multiple grounds for invalidity that cannot fit in the limited page limits of a single petition, to file multiple petitions at the same time, rather than doing what Apple did here, which was to wait a significant amount of time and then file serial petitions after sufficient time has passed. Because once a PTAB reaches a final written decision on any patent, it can apply Section 325 to stop any other related proceedings that were later filed and clean up its docket that way. So if you have any questions, please type them in and we'll try to address them at the end of the session. And also take note for CLA purposes to write down the code number 1, December 2nd. So if you write down the code, and at the end of each segment, we'll provide you with a new code to provide. And so with that, I'd like to pass the presentation to my colleague, Mi-Young Shin, who will continue talking about motions to exclude.
Thank you, Mark. Hello, everyone. My name is Mi-Young Shin. I'm a shareholder at Brinks Post-Grant, and my practice focuses on post-grant proceedings, in particular inter parte review. I have a significant experience in handling inter parte review proceedings and ex parte and inter parte re-examination when they're around. The topic that I'm going to present today is motions to exclude before the PTAB. Like the district court litigations, there is a vehicle before the PTAB to exclude evidence. That is motions to exclude. Motions to exclude are disputing admissibility of certain exhibits
under the federal rules of evidence, such as relevance, hearsay, and authentication. Evidence before the PTAB consists of affidavits, transcripts of depositions, documents, and things. And the rule indicates that all evidence before the PTAB must be filed in the form of an exhibit. A very interesting dynamic here before the PTAB is that once a party submits exhibits, then exhibits are in evidence. So it's entered into the record. So a party who doesn't like the evidence to be in the record should move for motions to exclude. That party moving for exclusion of evidence bears the burden of establishing inadmissibility of evidence. And the relevant rule behind that is 37 CFR Section 4220C. This section is about a motion practice before the PTAB. And before the PTAB, the moving party has the burden of proof to establish that it is entitled to the requested relief. So on the same token, a party moving for exclusion of evidence carries the burden of proof. And this is very different from district court litigation, because before the district court, a proponent of evidence carries the burden of establishing admissibility of evidence. So this is a very interesting dynamic for petitioners to remember about motions to exclude before the PTAB. The relevant authority for motions to exclude, the substance of motions to exclude, the federal rules of evidence applies. And there are 37 CFR Section 42 rule, Section 61 through 64 discusses the objections and motion to exclude. And of course, a patent trial practice guide is a very useful resource. And also various PTAB decisions on this issue are very resourceful. The first step for filing a motion to exclude is timely raising objections. The rule indicates that a party challenging admissibility of evidence must make a timely objection and preserve the objection via a motion to exclude. And there are particular timing requirements for objections. So for exhibits filed before the board has instituted a trial, there's a 10 business days from the institution of the trial. And once the board has instituted a trial, then objection need to be made within 5 business days from the submission of exhibits. And for the deposition evidence, objection must be made on the spot, i.e. during deposition. This timing requirement is very important. And also, when objection is made, objection must identify the ground for the objection with a sufficient particularity, so the other side know what is the problem and how to cure it. And the other side can submit supplemental evidence to cure the objection, and supplemental evidence must be served within 10 business days of the service of objection. Some technicality about motions to exclude. Filing timing for motions to exclude is set in the scheduling order. So that means that it's already pre-authorized by the PTAB. It's in the scheduling order, so the petitioners do not need to obtain the prior authorization by the board. And there are some page limits that applies to the motion practice. The motions to exclude oppositions are 15 pages and replies 5 pages. The substance of motions to exclude, in the motion to exclude, you have to identify where in the record objection originally was made, and whether the other side rely upon the piece of evidence sought to be excluded, and address the objections to exhibit in numerical order of exhibits. In the last you explain, it's objection. So hearsay, relevance, authentication, things like that. And really important part here is the focus of motions to exclude is about admissibility of evidence. It's not about the sufficiency of evidence. And in Plural System versus Leak Survey IPR, the PTAB presented the sample motions to exclude to consider. So first, identify exhibit and portion thereof sought to be excluded. For example, test data described in Exhibit 1005, Example 1. And then second is what's the objection, the hearsay, and when the objection was made and filed. You indicate the date and time and exhibit number. And whether petitioner relied on the objected data and what paper and what pages of that paper. And then last, explain why this is a hearsay. So please consider this format when you prepare motions to exclude. So again, motion to exclude is a vehicle to address the admissibility of previously filed exhibits. So this is not the place where you discuss the sufficiency of the evidence. And there's the one interesting IPR decision that I wanted to mention here is this ABB Inc. versus Royce Beef Corporation IPR. The patent owner raised the issue that the prior art publication does not have the publication date, or at least the patent owner argued that the petitioner failed to show that the date appearing on the cover of the prior art was in fact the publication date. And they actually raised that argument during the final oral hearing. So during the oral hearing, they mentioned, and the PTAB asked the question, why didn't you raise this issue before? And then patent owner indicated that they footnoted the issue in their patent owner response. But then the PTAB said that the patent owner did not file the timely objection, and then they did not move for a motion to exclude. So it wasn't really expressly said by the PTAB that motion to exclude is the way to go, but the PTAB clearly indicated that the patent owner could consider filing a motion to exclude to dispute this issue in addition to their substantive paper. So I think that's a pretty interesting decision to think about. And once you file a motion to exclude, the outcome of the motion to exclude is pretty not really favorable. So I have to say denier is highly likely. The reason behind this denier trend is the public policy concern. So post-grant proceedings involve patents which have very high public interest. So the PTAB thinks that it is better to have a complete record of the evidence submitted by the parties than to exclude the particular pieces for public access. So next slide shows the current statistics of motions to exclude by the PTAB. As you see from this slide, in 2015, as of now, over 90% of motions to grant have been denied, and about 9% of motions to exclude have been granted. So I'm going to discuss a few cases where the PTAB granted the motions to exclude. The first case is Corning versus DSM IP. This is the kind of classic situations for motions to exclude. So Corning disputed admissibility of two sets of exhibits filed by DSM. DSM is the patent owner. And one set is the experiment data prepared by DSM. And then second set of exhibit is Dr. Bowman's expert testimony relying on experiment data by DSM. And Corning's argument was that the experiment data was hearsay. Dr. Bowman did not personally prepare the data, so he didn't have a personal first-hand knowledge about the data. And DSM came up with the arguments that the experiment data was actually business record exception to hearsay, but the PTAB disagreed with the DSM and indicated that the data was prepared as a part of the preparation for IPR. So it was kind of unique documents. It wasn't generated as a part of the routine business operation. But the PTAB disagreed with the Corning with respect to the Dr. Bowman's expert testimony. They actually let the testimony stay with the proceeding because under the Federal Rule of Evidence 703, experts can rely upon facts or data that they have a knowledge. And that data or fact do not have to be admissible. And second interesting situation where the PTAB granted the motions to exclude was that the patent owner failed to make their experts available for cross-examination at the request of a petitioner. And then third case is also pretty interesting, that this IPR involving Scott Company as a petitioner and INCAP as a patent owner. The INCAP filed a motion to amend, and then Scott Company filed the opposition, and INCAP filed a reply to opposition, and then they filed a second expert declaration with a reply. But the Scott Company moved a motion to exclude the second expert declaration because it was actually supporting the original motion to amend, not the reply. And then the PTAB agreed with the Scott Company in that case. And this case is really interesting because in ABV IPI that I previously discussed, in that decision, the PTAB indicates that motion to exclude is not the proper vehicle to dispute the arguments that reply and its evidence exceeded the scope of the reply. It's not the right place, but Scott Company here actually filed a motion to exclude to dispute the scope of the expert declaration for a reply. So there's a little different approach by the PTAB as to the scope of the motion to exclude. So when you think about filing motion to exclude, the important thing is you have to raise your objection timely and then comply with the format in raising objection and preparing and filing motions to exclude. And again, the focus is admissibility of evidence, not the weight of evidence. So some strategic considerations for motions to exclude. When you are filing evidence, again, the dynamic of a burden of proof involving motion to exclude is different from district court litigation. So opponent bears the burden of establishing inadmissibility of evidence. And when you prepare the motion to exclude for filing, statistics shows that the denier is highly likely. So far, the board has denied almost all motions to exclude evidence for improper, deficient, or as moot. And again, remember the focus of motion to exclude is the admissibility of evidence, is not the weight of evidence. And in addition to motion to exclude, make sure that you raise all the arguments in your substantive paper and consider a motion to exclude as additional vehicle to dispute the different aspects of the evidence, i.e. the admissibility of the evidence. So thank you for listening to my presentation. CLE code number 2 for my presentation is post-grant proceedings. And there's a slash between post and grant. With that, I'm going to pass the presentation to my colleague, Danielle.
Hello, everyone. My name is Daniel Parrish. I'm an associate here at Brinks. Today, I will be covering prior art publications that require authentication, an issue I've dealt with in a handful of IPRs. Quick high level we're going to discuss. We'll go over the statutory basis and general rules and then jump into the case law. 7 or 8 cases that we'll try to get through in the interest of time. We'll hit some practice tips, and if there's time, take some questions. So first off, IPRs are limited in scope. Your petition is limited to prior art consisting of patents or printed publications, and we get that from 35 U.S.C. 311B. And that has a little bit of interplay with 35 U.S.C. 314, and that the petition must show that there's a reasonable likelihood that the petitioner will prevail. So you have to include all of the evidence that would demonstrate that a non-traditional prior art publication is indeed a printed publication as it's defined under patent law. So we see this a lot in conference presentations, whether they're posters or oral presentations, perhaps online publications or graduate student theses that are shelved in a university library. Some general rules to keep in mind. Courts look at this as a very fact-specific inquiry. They decide everything on a case-by-case basis. The key inquiry comes from a few different Federal Circuit and old CCPA cases, but the key inquiry is whether or not a reference has been made publicly accessible. And what that means is that it should be sufficiently accessible to the public interested in the art. They should be producing sufficient proof of dissemination or that someone interested in the art could access that publication. So let's jump into some cases. The first two here we might go through kind of quick. They're somewhat easy cases that we know what not to do now. So a petitioner cannot rely only on the publication date. That's insufficient. One case here, Square versus Unwired Planet. The petition just stated that it was published on September 30th, 1996. That was indicated in the ISBN number that said 1996-09-30. However, the patent owner pointed out that an ISBN may be obtained before a work is actually published, and there's no evidence how the ISBN actually relates to accessibility. They pointed out the work itself stated that it could only be obtained by the author. Reproduction required written permission of the author, and the figures were deemed confidential. So essentially, the author had all these other indications within the document that it was not meant to be widely distributed. So here the board said the petitioner failed to carry the burden and did not demonstrate public accessibility. Another case, Cisco Systems versus Constellation Technologies. Here they dealt with online publication. And again, the petition merely said that it was published as an internet draft in June of 1999, but they provided no other evidence of public accessibility. The patent owner pointed out that this was a draft, not a final version, and the document itself said it was valid for only a limited time, and it was not appropriate for citation. So again, the board said, you need more. The naked assertion that a reference is published is not supported by the record, and of note, the petition did not indicate how someone skilled in the art would locate the reference. So what do? Find an expert. But your expert must do more than say the same thing that your petition does. This case, Dell versus Celine Communications. Both the petition and the expert essentially said the same thing, that the reference was published in 1998 as indicated by the notation 1/88 on the title page. However, the patent owner pointed out that this 1-88 doesn't suggest publication or dissemination. It could have been the publication date, or it could have been the creation date or copyright date. And the board agreed with the patent owner. It said they give little to no weight to expert testimony that doesn't disclose the underlying facts or data. So here the expert was just pointing to exactly what anyone else could point to, the title page. So next we're going to cover a trio of cases, and this is an unofficial trio. That's my terminology, not the board's. But these all involve sufficient evidence of indexing or public accessibility in the realm of university publications. So the first one is Activist Research Corporation. Here you had a graduate student thesis that was completed and approved by faculty members and the University of Dean a year before the critical date. However, there is no evidence in the petition that this thesis was actually submitted to the library, that it was cataloged or indexed, and that no person actually reviewed this outside of that small circle who had reviewed the thesis. I believe there were 3 individuals. So all 3 of those people could access it, but there was no evidence that people outside of that small circle could. And the board here contrasted the case with an old Federal Circuit case, In re Hall. And this is one where there was actually university librarian testimony. The librarian testified about the library's process for indexing, cataloging, and shelving. And they pointed out how in re Hall, the thesis at issue had actually been looked at by a handful of other people outside of the university, and that was deemed sufficient. So a little practice tip, if you're dealing with a thesis like this, try to get a librarian or a library administrator to testify about the actual process of searching, indexing, cataloging, shelving, those sorts of things. The second case we have here is Groupon versus Blue Calypso. This, again, was a technical report published by a university. However, this was just a university department. They said technical report. I was thinking like a white paper, but it was only available on that department's website. So you'd click a link on the EE department website, and you could download this publication. Additionally, one of the authors had his own personal publications list where you could download the link. And so if you were in the field and you saw a report by this author or something from the university, you could go to those websites and find this link. And that's what the patent owner pointed out. This was not indexed. It was just an internal departmental technical report. It was not a journal. And there's no evidence of how an interested person would locate it. There's no testimony on how you might use a search engine or other queries to stumble upon or to find this report. And the board again agreed with the patent owner that there's no explicit reference to the report or link within any other of the author's publications. There's some other case law where if a journal publication cites something that's less public, for example, a thesis, that link might be enough to render it public. And they drew analogies to unshelved thesis and FTP subdirectory cases. In those cases, there might be an online publication, but only for those people who know the correct URL in order to access FTP. In a third case, Global Foundries versus Zond, the reference at issue here was a Russian thesis, and the petition submitted the thesis itself in English translation, as well as a catalog entry as evidence. They pointed out that the Russian State Library, by definition, is established to share the information that it houses with any interested person, and there were also subsequent journal articles that pointed to this thesis, and those articles were published before the critical date. I included a screenshot here of the actual catalog entry that was submitted to the board. And you can see it has this language, imprint Moscow 1994. And that's what the patent owner challenged. They're saying that there's no evidence that this imprint Moscow 94 is equivalent to being cataloged or indexed. The board did not buy that argument. They said that there's no explanation why a library would take more than 7 years to catalog and index a thesis. Here there was a lot of time, and the board placing weight in that catalog evidence. Of note, the patent owner here also did not challenge the admissibility or authenticity of the catalog entry. And the board took that, they said that since they didn't challenge it, they would take it at its face value for what it says. Moving on to another case, Temporal Power versus Beacon Power. Here they dealt with a conference presentation. There's a PowerPoint that was presented or allegedly presented at a conference. But the patent owner pointed out there is no evidence that this version was the actual version that was presented at the conference. And they also testified that there was no evidence that all the other things that you have to demonstrate when you try to say that a presentation is publicly accessible. So you might want to include how many people were at the conference, were they of skill in the art, were any paper documents or physical documents distributed, things like that. So the board here contrasted that with two Federal Circuit cases, In re Klopfenstein and MIT versus A.B. Forsha. All right, we're going to switch gears here and talk about online publications for the next couple cases. There's a new or relatively new tool called the Wayback Machine, and it's by a company called the Internet Archive, and what they do is they archive web pages at various dates. So if you have a website that you want to use as prior art, you can look at it today, but you're really interested in how it looked on the critical date or before that. So the Wayback Machine may have archives of that web page or that publication as it looked around the time of the critical date. So this first case, Nestle Oil versus Reg Synthetic, they submitted an expert declaration of someone who had gone online and retrieved this Wayback Machine printout. So they had personal knowledge of the retrieval. However, the patent owner pointed out they did not have knowledge of the website itself. They weren't a webmaster or administrator. And the board stated, they sided with the patent owner and said that if you're going to offer a printout of a web page, you must have a proponent of the evidence must authenticate the information from the website itself, not merely the printout. So our practice tip is obtain an affidavit from the Internet Archive if you're using the Wayback Machine, or another administrator if you're using a website. One case where this was successful was EMC Corp versus Personal Web. There they found an expert who had personally verified the software. Last two cases, assuming we have time. Draft documents may be deemed printed publications if there's enough evidence of public accessibility. So we have a case here, ZTE versus IPR licensing, where the draft document was a prior art printed publication, and our next case goes the other way. So in this case, these draft standards are published up to 4 times a year. There were standard-setting organizations. So as the working groups progress towards a final release standard, they will publish quarterly versions so that people in the industry can keep up with this. They could even sign up for email distribution lists. The patent owner pointed out that these were just working drafts. They weren't yet ready for public dissemination. The board said no. Just because it's a draft doesn't mean it was not publicly accessible. Here they were distributed by email lists and published. So even though pre-final draft, these working drafts were deemed public. In a similar case, Samsung Electronics versus Rembrandt Wireless. At issue here was working group draft standards. So here, the documents were distributed within those, a working group, but not to people outside of the working group, for example, in the industry. The patent owner pointed out that these documents are password protected. They were not distributed to, quote, the entire internet. That was in the petitioner's expert declaration, actually. So people who weren't members of the working group could not actually access the draft standards, and they wouldn't know about the meetings where these things were discussed. So the board said, no, this does not qualify as a printed publication. Some quick practice tips here. If you're going to include an expert declaration, we recommend that you do include it if you're dealing with the situation. Include a step-by-step description of how an expert would have found the reference at the time, what they might have queried, where they would have typed their searches, stuff like that. Include why they would have looked where you're telling them they would have looked. And if possible, it's great if you can have an expert with personal knowledge of the public accessibility or dissemination. For example, an author of the paper or a librarian or someone, a webmaster. And if you do use the Wayback Machine, get a petition. And these may be helpful even if they're after the publication or after the critical date as corroborating evidence. Last CLE code is Brinks. And we will open it up for questions at this time.
All right, thanks, Daniel. It was an interesting presentation. And Myung, yours was also very insightful. We have a time for a few questions, and I see a few questions have been submitted already by some of the attending audience. So I think the first question here, I'll pass it to Dan. You know, it seems like the question is, what if people with personal knowledge are unwilling to testify as experts? And I know in your presentation you were pointing out how a lot of the decisions were based on the evidence of experts or other persons providing additional corroborating information.
Yeah, it's a tough situation and one that we've run across. Sometimes the people who have the most knowledge they might be on the other side of the case, or they might have they might not want to alienate either party because they're clients. So what you can do is find someone who may have been interested in the art, so someone of skill at the time, and for example, these working groups, if you can't find someone who's part of the working group, maybe someone who was outside in the industry who would access these working group documents in order to keep up with the progress of the standards. Yeah, it's a tough situation.
Yeah, it sounds that way, Dan. All right, Myung, I guess here's a question for you that came in. When and how does the board issue a decision on a motion to exclude?
Yeah, that's a very interesting question. Usually the motions to exclude are filed after the parties complete their substantive briefing and then before the oral hearing. So the board issue a decision on a motion to exclude with the final written decision. Sometimes it's embedded in the final written decision. Other times, if the issues are very substantive, such as like the Corning case that I discussed during the presentation, they issue the separate decision on a motion to exclude in addition to the final written decision. But a lot of cases, the board embedded their decision on a motion to exclude in the final written decision.
All right. Thanks, Myung. There's a question here I will address. It asks, how common is it for the PTAB to rely upon estoppel? So that's an interesting question. I haven't done any statistical analysis to see how common that is, but it does come up on occasion, and I think it's happening more and more now that the board is issuing a lot of final written decisions. It now, once a final written decision has been entered, it does give them an opportunity to apply the estoppel provisions of Section 325E1 against serial petitioners who are filing a lot of petitions on the same patents. So I think we'll be seeing it more and more as a means for the board to kind of manage their docket and streamline and make more efficient their proceedings. I mean, if they have multiple proceedings against the same patent, once the first final written decision is held and they find claims invalid, I don't think there's a reason for them to continue maintaining later subsequent petitions against the same claims. So I see that we're already past the hour, and wanted to thank everybody for attending the webinar today. We'll be concluding, and I wanted to remind everybody not to forget to write down the CLE codes to get your CLE credit. Whereas a reminder, code number 1 was December 2nd. Code number 2 was post-grant proceedings. And code number 3 was Brinks. So if you have any questions about the presentation today, please feel free to send an email to any of us with your questions relating to our presentation, or if you have other questions about the TPAB proceedings in general, please contact us and we'd be happy to address them with you offline. So thank you very much for attending, and I will, I guess, turn back to our technical assistant to close out our presentation. Thank you very much.
And thank you for attending. This concludes today's webinar.